there was one other thing that the court found that I think is what I want to get your take on and I'm interested in. And that had to do with the government's argument, whether in their brief or at oral arguments about sort of responsible citizens are the only ones who have their gun rights protected by the Second Amendment. And they sort of maybe even kind of went out of their way to say that they don't hold that view.
That's right. And as Justice Thomas pointed out, this responsible theory didn't get support from a single justice on the court.
Right. Because there's like a million concurrences in this case, right? Pretty much everybody.
And so from the Solicitor General's point of view is, well, we won the case, but they hated our brief. So what this goes back to is, starting with Heller, you have a lot of references to law-abiding, responsible citizens. And the Solicitor General's office said, oh, that creates a rule. So anybody who any class of people who Congress or a state legislature says is not responsible, well, then they can be divested of all their Second Amendment rights. And obviously the Solicitor General was, in doing this, looking forward. For example, currently pending before the court on a cert petition is United States v. Daniels. That's a case from the Fifth Circuit where there was a guy who admitted he was a marijuana user and also a gun owner, but there was zero evidence that he'd ever used or carried a gun while he was under the influence of marijuana. And the Fifth Circuit said, as applied to Mr. Daniels, the ban on firearms possession by someone who is a user of an unlawful user of a controlled substance, which he was under federal law, that's a violation of the Second Amendment. And likewise, there's also a cert petition pending a case called United States v. Range. That comes out of the Third Circuit, where there was a guy who committed $2,000 of food stamp fraud in the early 1990s. Since then has gone straight, no blemishes on his record. And the majority of the Third Circuit en banc said, as applied to him, considering it was a nonviolent offense to begin with, and the lapse of time since it happened, there's no plausible way you can say he's more dangerous, than the average guy walking down the street. And the Solicitor General's office doesn't like either of those opinions, and they were hoping to get responsible established as the standard, which they can then say, well, he committed misdemeanor food stamp fraud, so he's not responsible. And this other guy, he's using marijuana in violation of federal law, so he's not responsible. And the court firmly rejected that. Zero support in the court for that approach.
Right. And at oral arguments, the Solicitor General seemed to kind of try and backtrack a little bit and rely more on this categorical dangerousness. Like if you're in a certain category that Congress has deemed to be dangerous and irresponsible, that you can't own guns. What was your take on the court's opinion on that?
They didn't think much. Well, as was pointed out, the Solicitor General at oral argument backpedaled heavily and under pressure said, oh, when we said responsible all those times in the brief, what we really meant was dangerous, which would be a much better standard. But the court didn't even really get into that meta issue of,
right.
Describe the entire category of people who can be disarmed. And the court could have said, well, anybody who's been proven, anybody who's dangerous. And you could look at that, whether that's by class of people or by an individualized finding. But the court didn't do that. They wrote a narrow opinion that said this statute is constitutional because it disarms a guy who's individually been found to be dangerous.
Right. Yeah, I thought that was, I don't know, it's interesting because they wrote about, obviously, like you just said, their termination was on an individual basis for Rahimi himself because he had a personal individual hearing about his, whether he was a threat to his mother of his child. but there's sort of a passing reference, I guess, in the majority opinion about it doesn't necessarily mean that they're saying there couldn't be categorical dangerousness standard. They're just not getting into it really.
Precisely. It's just one sentence and they brush it off. But even at that, it's notable they didn't rely on any of the categories. So to take a step back for the audience, you can have disarmament under federal law sort of based on in two ways. One is, as in this case, a court has actually found that you're dangerous. Or it can be you're in a class of people who the court considers to be dangerous. For example, unlawful drug users, persons who have been dishonorably discharged from the military, people who have renounced their citizenship, people with various categories of convictions. And a lot of the argument from the Solicitor General and the amici on the SG side was to blend those together and to create a grand tradition of disarmament. Some of it based on categories, some of it based on individualized decisions. And the court didn't go for that. They could have looked at disarmament based on categories, such as during the American Revolution, people who were loyal to the tyrannical British government and wouldn't take a loyalty oath to the United States. And they were disarmed and had their guns taken and given to the local militia. But the court didn't rely on any of those categorical things to justify the statute involving Rahimi. The court relied solely on historical examples based on a government official deciding that a particular individual was dangerous.